we go. I turned it on too late. Okay, let's get started, everybody. We've got a lot to get through today. First, we will do requests for bill introductions. Anyone on the committee have requests? I'm not seeing any hands online, nor any in person. I do have one on behalf of the Secretary of State's office. It's RS0144. This would add a narrow exception to the Open Records Act related to cybersecurity at public agencies. It was pretty much Senate Bill 454 last year. It moved through the Senate, but by the time it got here, we weren't here anymore. So any questions? Any objection? We will get that one introduced. Anyone else here today with a request? Just a reminder to everybody, Monday is our deadline to have committee bill requests. So your time is almost up. Let's see, if we don't have any more requests, we will get started. We have one bill hearing today, House Bill 2126. Yes, sir.
Would it be okay for Representative Coleman to take one of the inside seats?
Oh, that's fine. Yeah. Grab a seat. Spread out. More distance we can get, the better. Okay. Opening the hearing on House Bill 2126, and we will have Natalie give us an overview.
Thanks, Mr. Chairman. House Bill 2126 would provide immunity from civil liability for COVID-19 claims for adult care facilities. Current law in KSA 60-5502 and 60-5506 provide that adult care facilities, which for purposes of this act are defined as nursing facilities, assisted living facilities, and residential healthcare facilities, have an affirmative defense to liability in a civil action for a COVID-19 claim if that facility was acting in substantial compliance with public health directives and they were either required by law to reaccept a resident who'd been removed for COVID-19 treatment, or they are treating a resident who has tested positive for COVID-19 in compliance with law. This bill would amend those sections. So the first change in KSA 60-5502 would expand the definition of an adult care facility to include any adult care home as defined in KSA 39-923 and centers approved by the Centers for Medicare and Medicaid Services as a program for all-inclusive care for the elderly. I would note in this section, you might have noticed that I made a typo. It says adult case on page 1 in line 14 should be care. So if we do work this bill, I'll bring you a technical amendment for that. The bill would also amend KSA 60-5506 to provide that these facilities would be immune from liability for any COVID-19 claim. That immunity would not apply when gross negligence or willful, wanton, or reckless conduct would be established. And the amendments made to this section would be applied retroactively to conduct that happened on or after March 12th, 2020, and through the end of the current disaster emergency related to COVID-19. And I can take any questions.
Questions for Natalie, Representative Hoheisel?
Thank you, Mr. Chair. Thank you, Natalie, for that breakdown. Just some clarifications. This does not include IDD communities or mental health crisis centers, correct?
Mr. Chairman, those would not specifically be included. Maybe just for reference, I will read you the definition that's found in 39-923, since that will be the one that we'll be cross-referencing now. So that says an adult care home means any nursing facility for mental health, intermediate care facility for people with intellectual disability, assisted living facility, residential healthcare facility, home plus, boarding care home, an adult daycare facility. And so those would be what would be included if this bill were to pass.
Thank you for that, Natalie. Thank you, Mr. Chair.
Representative Owens.
Thank you, Mr. Chairman. Natalie, can you tell me, back in House Bill 2016 during the special session, can you tell me what we provided for healthcare providers and how that is different than what we allowed for adult care facilities in 2016?
Mr. Chairman, the healthcare provider immunity provisions can be found at KSA 605503. And if you guys want, I can have that distributed to you. In fact, actually, through the powers of technology, I think I may be able to even put it up there for you to look at now. So you can see there that for healthcare providers, we provided immunity from civil liability for those acts, omissions, healthcare decisions, or rendering or the failure to render healthcare services related to COVID-19. So that immunity versus an affirmative defense, but also over here on the healthcare side, it's not for any of those COVID-19 claims as defined in the act previously. It's just for the acts, omissions, and healthcare decisions. And then over in the healthcare side, we do still have that provision that this immunity doesn't apply when gross negligence or willful, wanton, or reckless conduct is established. And then there in subsection C, paragraph 2, this section also doesn't apply to healthcare services not related to COVID-19 that have not been altered, delayed, or withheld as a direct response to the COVID-19 public health emergency. So that's what's currently for the healthcare providers.
So if I may, Mr. Chairman, the primary difference is we provided immunity for healthcare providers, but we only provided an affirmative defense for our adult nursing care facilities.
I think that would be one of the big differences. The other difference on the adult care home side is we had those provisions related to their caring for the folks pursuant to law and following those public health directives.
All right. Thank you, Natalie. Thank you, Mr. Chairman.
Representative Samsel.
Thank you, Mr. Chair. This follows up on the previous good representative's questions, but is the other distinction that I think I'm seeing here is this, if they're required to bring in certain patients who may be positive for COVID or something of that nature, that this is also extending protection to that realm? Am I reading that correctly?
Mr. Chairman, those provisions are in the current law. So that is what is provided for currently.
And then Natalie, if you could, I know when we passed HB 2016, it seems like there was some distinction, perhaps debate between how we differentiated between businesses and then those here in the healthcare fields. Can you help remind me what those were? I don't know if they'll be significant or not, but I do recall that there was some difference.
Mr. Chairman, this act does provide for general business immunity as well. Those provisions can be found at KSA 605504, and I'll go ahead and show you those provisions. And so this is a little bit more general, but basically people conducting business in the state will be immune from liability in a civil action for a COVID-19 claim if the person was acting pursuant to and in substantial compliance with public health directives applicable to the activity.
Thank you, and thank you, Natalie. If I recall correctly, it seemed to be that might be a little bit stronger protection. I may be wrong, but I'm sure we'll get into that with proponents and opponents. So thank you, Mr. Chairman.
Representative Carmichael.
Thank you, Mr. Chairman. Two questions for the reviser. First, directing your attention to page 3 of the bill at line 3. And part of this is, of course, existing law, but now it applies immunity from liability as opposed to the affirmative defense. But it appears that the language would make these healthcare providers or nursing facilities, long-term care facilities, whatever the proper term is, it appears that it would make them immune from liability in not only civil actions, which are lawsuits, but also administrative fines or penalties. And I presume that would be a reference to penalties leveled, at least in part, by the Department of Health and Environment for substandard care. Am I reading that correctly?
Mr. Chairman, I think so long as those penalties were levied against the facility for something that meets the definition of a COVID-19 claim, then they would be able to assert the immunity provided for in this section if this were passed.
And I do agree with your reading of that, and I appreciate that distinction. But I think what this means is that KDHE can no longer penalize, do anything other than just write reports if there are violations that are related to COVID-19. Is that what that means?
Mr. Chairman, so long as that did qualify as a COVID-19 claim, then I think that could be an accurate reading.
And I don't want to belabor this, but I think there is an important legal distinction here, because claims are generally thought of as one party claiming damages, monetary damages against another. We call that a claim. On the other hand, when KDHE levels a penalty or a fine, that's not, at least to my understanding, a claim. That's something different than one party claiming money from another. How can I reconcile what this bill means in the context of penalties and administrative fines if they're not traditionally what we consider to be a claim?
Mr. Chairman, I do agree that the kind of general definition that we use in law when we're talking about claims is, typically with respect to a lawsuit of some type, which I think is kind of true here. If you do look up at the on page 1, starting at line 19, that is what is defined here as a COVID-19 claim. So I suppose if someone was making that type of claim to KDHE, about the care of someone in one of those facilities. So I generally agree with you on, what we typically think of how we use the word claim.
I'm not sure how we fix that, but I appreciate you helping me with the law. My second area of question, Mr. Chairman, concerns page 3 at line 31. And there we purport to make the changes in section 2 retroactive to March 12 of 2020. When we talk about retroactive application of a civil law or statute, at least in the context of a tort, there's a concept known as vested rights, which cannot be changed by the legislature in civil actions retroactively. However, here we are purporting to make an immunity retroactive as opposed to an affirmative defense retroactive, which is basically what we had before. Can you help me understand how it is constitutional for us to retroactively change the law by creating an immunity that was not present at the time of tortious acts, which may have occurred between March 12 of 2020 and say the present or whenever the declaration expires? How do we reconcile that constitutional requirement?
Mr. Chairman, and we've had some conversations about this before with respect to some other bills, so this might sound familiar, but when we draft this, we're kind of just saying this is the intent of the legislature that this be applied retroactively. I think Representative Carmichael is referring to a concept similar to like a statute of repose. And as we know, based on case law, we cannot impact a statute of repose retroactively. And so a court who is interpreting this would just have to determine whether they believe that retroactive application would meet the constitutional requirements.
So, Ms. Scott, I think in essence it means that if I ask you to draft a statute that's unconstitutional, you'll do it for me. You're not offering an opinion one way or another as to whether this purported retroactivity is or is not constitutional. Would that be fair?
That's correct. I mean, if asked, I would happily draft a bill that I believe would be unconstitutional. That is part of our job. And so it's just hard, as I'm sure you're all aware, the case law surrounding this topic is pretty complicated. And so it's difficult, if not impossible, for me to tell you whether I think how a court would decide in this case.
And so when we create these types of questions in a statute, what it engenders then is eventually litigation up to and including the Kansas Supreme Court, where presumably after months or years and expense of litigation, they'll tell us whether or not our work is constitutional or not, or maybe the Court of Appeals tells us that. Is that generally the way this works?
Yes, I suspect that should someone bring a claim against one of these facilities, the facilities would assert this immunity, and then we might get an answer to that question.
I very much appreciate your help. I know that I was asking you questions, not always which have answers, so thank you.
Hoheisel.
Thank you again, Mr. Chair. Natalie, this may be a question for you. You may know, or it may be a question for research, but are there any active ongoing lawsuits involving COVID-19 and our adult health care facilities right now?
Mr. Chairman, I don't know that. If someone in research does, they can pipe up. I suspect that some of the proponents or opponents may also know that.
Thank you, Mr. Chair. For the last question for Natalie, Representative Samsel.
Thank you, Mr. Chair. The good representative from Sedgwick County triggered this one in my mind, but as I read the bill, I don't see a severability clause in there. So let's say we want the rest of this law to stick regardless of how if it passes in its current form with retroactivity. Do we have a savings clause or a severability clause, if you will, or can you help us understand that?
Mr. Chairman, I think I might need a little clarification on that question. Are you suggesting that you would want to sever certain parts of the amendments in this that we're making here?
No, I'll try to ask a better question. Let's say the section that the good representative pointed out there about retroactivity, it looks like that's on page 3, starting at line 31. Let's say that does get litigated and the Supreme Court ultimately concluded that it is unconstitutional for any reason. What I think we would all not want is for the court then to strike down the remaining provisions of the rest of the entire bill. So it would be a severability clause of just saying, the legislator's intent is even if that line 31 section, if you will, gets stricken, the rest of this, we would still intend to be Kansas law.
I understand what you're saying now. So there isn't a severability clause in there now. We could always add something like that. As all of you know, severability is a determination that is made by the court, but it's not uncommon for us to include legislative intent with respect to severability in bills like this.
Thank you, Natalie. Thank you, Mr. Chair.
Thank you, Natalie. Committee, we're going to do like we've been doing recently. We'll wait until the proponents are done and ask questions. Then we'll wait until the opponents are done and ask questions. Ask your 2 best questions because you may not get a shot for more. We're going to do proponents until about 4:25, and then we'll switch to opponents. And then if we've got more time, we'll come back to additional questions. Conferees, if you could try to do it in 2 minutes, no more than 3, that would be great. Vice Chair Ralph's going to let you know when you hit the 2-minute mark, just to try to keep us on track. As you all know, we have your written testimony. If somebody said something before, you're welcome to say, I agree with them and not repeat it all. Just trying to keep us on track and give both sides an equal opportunity to share their concerns. We will begin with proponents. Just going to go down the list. First up is Mark Maloney.
Chairman, members of the committee, thank you for the opportunity to address you regarding my clients, Progressive Healthcare Alliance, and their concerns related to House Bill 2016 and what is proposed in House Bill 2126. I have practiced law in the great state of Kansas for 31 years. The last 20, I have spent almost exclusively defending healthcare providers in professional negligence litigation. I am currently, to address one of the questions from earlier, I am currently defending a nursing home in a COVID-related case in Sedgwick County. We have articulated the affirmative defense, and the point of my comments today is to articulate the difference between what we are going through in the affirmative defense process versus what we would have enjoyed had the immunity clause been available. Under 2016, I was limited to what I could do in defending my nursing home client. I had to assert the affirmative defense. That shifted the burden to me, and it caused my clients to incur additional costs. You might think, what are those costs? I'll tell you what those costs are. I had to spend considerable time at my client's facility pulling frontline healthcare workers out of patients' and residents' rooms to come into a conference room to meet with me to talk about whether protective personal equipment was available, what vendors had been contacted, what the budget looked like. This caused the facility to call in extra staff to cover those shifts. It was a time-consuming and expensive endeavor. I believe House Bill 2126 affords those types of facilities an immunity that properly shifts the burden to the plaintiffs and make it clear the availability for plaintiffs to pursue claims would still be available if they could demonstrate there was gross negligence, willful or wanton conduct by the healthcare provider. I support the amendment in 2126 and ask the committee to adopt it. It would be of tremendous help to my clients and the Progressive Healthcare Alliance. I'll stand for questions at the appropriate time. Thank you.
Thank you. Audrey Dunkel. Online.
Thank you, Mr. Chairman, for the opportunity to speak on behalf of our hospitals. We do have 122 community hospitals within our membership, and while we generally don't speak on issues of nursing facilities, it's important to know about a quarter of those actually do have nursing facilities as part of their service to the community. So you can imagine the confusion when they are treated differently as a hospital than they are as a nursing facility provider when they are applying the same standard of care across both sets of facilities. This has led to some things that have been very difficult for our providers as far as the nursing facilities, because they have had to lock down those nursing facilities harder than they maybe would have because they are concerned about the liability. And included with my testimony is some testimony from the Mitchell County Hospital Health Systems. I asked their CEO, who had reached out to me with some concerns about this in the past, to share what's happening at his facility and what it means for those residents at that facility, because they do have a disparate liability protection. And what that has meant is they've had to lock down visitors more at their nursing facility. Of course, it has a really, really hard impact on those residents in those facilities, and they have seen that negative impact on those members. And so they are really looking for some relief from you with the legislature. Thank you, Chairman. I will answer any questions when they come up.
Thank you, Audrey. Next, we have Charlotte Rathke.
Good afternoon, Chairman Patton and members of the committee, and special greetings to Representative Ralph from days gone past when I served in Dodge City and we attended the same church. Charlotte Rathke, administrator at Locust Grove Village in La Crosse, a small facility, a 38-bed skilled nursing facility, and I want to focus on the fact that this is a novel disease. I stress that word because it's important, I believe, for the discussion. It's something new and never resembled, something we've formerly never used and known. No one knew how to experience this. Our governments, our businesses, and our healthcare entities were no different. And so I'm asking, why are nursing homes being singled out as providers differently than others? It's a virus. It spreads quickly. It's in clusters all across our nation and our world, in correctional facilities run by the state, in hospitals, in nursing homes, in our schools. It certainly is deadly, and it can impact our compromised elders even more. Our story, I feel very lucky about our story. We have been a 4-star facility for years. We've never had infection control deficiencies for over 5 years. We passed 4 COVID inspections during this time frame. We kept the virus at bay for months on end, but when it struck with a vengeance. Our staff did everything the same that we had done before, and we continue to do, even now, for a number of weeks, 6 to 8 weeks of being clear of the virus again. And yet our county positivity rates go up. Our community is still having issues with this, but we're protecting our residents. Are we doing things different? No. We're following the same practices, the same guidelines that we have always practiced. And for that reason, I remind you, it's a novel thing. And to set one organization type, healthcare entity type out for discussion differently than others, to me, is unfair. There's a lot of detrimental things that happen with this kind of discussion. First, it's projected that the nursing home is the reason that elders become sick and die. It creates fear. It creates fear for our residents. It creates fear for our families. We had employees quit. We had people who wouldn't come to work for us because of this, the fear. It creates a very low morale for people who do a very hard job day in and day out. And we're doing the best we can to combat this issue. And all it does is create that negative perception over and over of the images in nursing homes. Aging happens. Illness happens. People die. They die of cancer. They die of Alzheimer's. They die of heart disease. They die of COVID. And it happens, and it's no one's fault. So it's a case of fairness. I ask you to support this bill because I feel it's the right thing to do. All healthcare providers deserve partial and just treatment for the work that we do. Thank you.
Thank you. Next, we have Rachel Munger.
Thank you so much, Mr. Chairman. I am Rachel Monger with Leading Age Kansas, and if you don't know us, we're the State Association for Not-for-Profit Senior Care. We have 160 member organizations across the state. The not-for-profit senior care sector is a unique one. It has a strong tradition in Kansas, and we make up half or more of the senior services being provided in Kansas. We have deep roots in our communities. Nearly all of our members provide nursing home care, but only a handful have chosen to provide nursing home care only. In our membership, we also have assisted living, home plus, residential health cares, long-term care units or critical access hospitals, senior housing, home care, hospice, Meals on Wheels, you name it, our members do it. And more than half of them are in communities of less than 4,000 people. And so the loss of any one of them or the detriment to any one of them plays a huge part in their communities and is a huge harm to them and the elders that they serve. So House Bill 2126, as you know from reading it, the liability protections do not apply to acts, omissions, or decisions that result in gross negligence or willful and reckless conduct. What the bill does do is provide protection for the 99.9% of senior care providers in this state doing their best to care for residents during an unprecedented public health emergency that has gone on for 11 months and counting. As I wrote in my written testimony, back in November 2020, the Associated Press worked with researchers from the University of Chicago to study nursing home outbreaks in 20 states, including Kansas. The researchers found that the quality of a nursing home was unrelated to the number of COVID-19 infections they experienced. The biggest factor in nursing home outbreaks was the degree of infection spread in their community, something nursing homes have no control over. If the county had a high infection rate, so did the nursing home, no matter how good of care they were providing. Researchers found that the main contributors to the surge in nursing home outbreaks were high community infection rates, high number of asymptomatic carriers, lack of access to timely testing and testing supplies, nursing home staffing shortages, and shortages in personal protective equipment. And the issues pointed out by these researchers were not things going on early on in the pandemic. These issues were happening in November and December and still continue today, and you will see that in my written testimony. We need House Bill 2126. Singling out long-term care for personal injury and class action lawsuits threatens the very existence of the senior care system in Kansas, a system that was already on the verge of crisis before the pandemic started. It has already caused spikes in liability insurance markets that will quickly become unsustainable and may ultimately affect our healthcare stabilization fund. The affirmative defense for adult care homes, even if it was written broadly enough, it doesn't give us what we need. Immunity from COVID-19 related claims will ensure that such issues are addressed early on in the case and minimize the considerable financial and resource drain of unwarranted lawsuits. Thank you very much, Mr. Chair.
Thank you. Colin McKinney. Colin's online.
Good afternoon, Mr. Chairman, members of the committee. I am Colin McKinney, and I'm speaking in support of House Bill 2126, but would ask that it be amended to also include licensed providers of intellectual and developmental disability services. For those who aren't that familiar with the services that we provide, they're very similar to what you might find in an adult care facility. To qualify for Medicaid-funded services that organizations like mine provide, you actually have to be assessed and determined to reach an institutional level of care. And so we are a direct alternative to a nursing facility or other adult care facilities, state hospitals or private intermediate care facilities. We are similar in many ways. We provide around-the-clock care to people who can be very vulnerable. They may need assistance with their very most personal needs each and every day. But one thing that is different about the services that we provide is that you've seen the video or the pictures of families visiting their grandparents or older folks receiving services in a nursing facility, and that was happening through a window or by video call. We certainly tried to use those types of mechanisms to prevent people from being exposed to this virus, but we don't have the ability to tell them you cannot leave, you can't go out in the community. In one case, the concern was the person really needs to go to their job every day, despite the fact that they're coming back to a home where other vulnerable people live every night. And so our primary recourse was to encourage, ask, and entice people to go along with our safety precaution measures. But what we find now is that without the protections that might be afforded by 2126, we might be subject to liability because others made decisions to put themselves and those that they lived with at risk of harm. And so I would greatly encourage you to consider also including organizations like ours that are licensed by KDADS to serve very vulnerable Kansans. One last thing that I would share with you is that at insurance renewal time this year, we found that the insurance companies no longer want to cover anything related to a pandemic like this. And so if we're talking about the simple costs of defending against a claim which may be mostly without merit, all of that would come from us and detract from the resources that we use to serve the people who rely upon us. And so having the immunity that is afforded through 2126 might help us avoid some of that. Again, I appreciate the aspects of the bill that speak to those who knowingly disregarded the guidance, which may have led to someone becoming infected. That makes good sense to us, but would ask you to strongly consider passage of this bill and also include an amendment to include providers of intellectual and developmental disability services. Thank you so much.
Tricia Phillips, I believe she's online as well. I see you. Tricia, can you hear us? Looks like you're still muted. There you go.
Can you hear me?
Yes.
Okay, thank you. Sorry, I don't know what was going on. I thought it was unmuted on my end. Okay. So my name is Tricia Phillips. I'm the Chief Nursing Officer for Axiom Healthcare Services, and we have skilled nursing facilities, assisted livings, and home pluses in Kansas. And I just think that I agree as earlier that we don't believe that if COVID is in your building or if it's not in your building, there's always a direct relation to the quality of care that you're providing. We run fairly good nursing homes. Ours look really good on paper. I mean, we have 4- and 5-star facilities. They all have national quality Baldrige Award winners. We do everything that we can to follow CDC, CMS, KDHE, KDADS, regulatory guidance, even though lots of times that's very contradictory. It takes a lot to sort through all of that. And you can literally call and ask something and then call back in 10 minutes and get a different answer. So it takes a lot on our end to keep all of that straight. And I think that even though we're doing all of this, it still got into our buildings, and we're losing staff because of this. They're saying, I don't want to be in the middle of a lawsuit when I'm doing nothing different. I'll go to the hospital and work. So I just don't think it's fair. Do I think if we're negligent, absolutely we should be held responsible. If we're not, I don't think that that's the right thing to do. We had 26 surveys in last year from March until December with 0 deficiencies. Yet we're still, I mean, we still had COVID. Unfortunately, we still had some in our buildings. I ran around the state like a mad woman procuring PPE when this first started. It's costing us a lot more money to get PPE. The prices have gone up drastically. We have it, we're using it. It just doesn't seem fair that the hospitals, the doctor's offices, sometimes when it comes into one of our buildings, we're getting it from somebody who brought it from a dialysis center, a hospital, a doctor's office, and then we're being punished for it because now they're back at our building and isn't necessarily our fault. And then we also are the ones that are paying the price with the surveyors. They've been in our buildings, like I said, 26 times in the last year. So they're there frequently checking. And if we're doing something wrong, then we should be held responsible. But if we're not, then I don't believe that that's what should happen. I just think it's an ever-changing field. Nobody knows. So we're doing the best that we can with what we have. And so I would just ask that you consider the immunity for long-term care as well as you do for the hospitals. Thank you.
Oh, thank you. Haley Ordoy. And I'm sure I butchered that, so you're welcome to correct me and not be on the clock while you do it.
That's all right. It's Ordoin, and I'm used to it after 21 years. So, good afternoon. Thank you for the invitation to come and present our perspective. My name is Haley Ordoin. I'm an administrator and owner, actually, of a small facility in North Central Kansas, but I'm also here representing Kansas Adult Care Executives. We are a collaborative association, nonpartisan, nonprofit, professional association. We represent the individuals, so the administrators, the operators primarily. So we're the ones on the front lines dealing through this pandemic. We're here today to obviously advocate in favor of House Bill 2126, and we know that many legislators have supported providing this, and we just want to say thank you. Thank you for your efforts. We greatly appreciate that. I wanted to bring the unique perspective, though, of someone on those direct lines for you to fully understand the ramifications that this decision, one way or another, could have for us. Long-term care, adult care homes, we are and always have been healthcare providers. And saying that we're anything other than that is very confusing. If we're not a healthcare provider, then I would really appreciate someone's definition of exactly what we are. We've been previously carved out, and we don't understand why. We literally cannot be heroes one day, especially for photo ops, and then turn around and be painted as the villains the very next. Liability insurance rates have been referenced. They are skyrocketing. That is something that we're not sure if we're going to be able to maintain because they already increased because of the industry. You throw COVID on top of that, and now those insurance carriers aren't sure what they might be facing, as are we. So we're facing an uphill battle. When COVID hit, we were defenseless. I think we've seen that as a state, as a country, as a nation, and as a world. We didn't know what we were facing. It was an invisible enemy that came, swept in through the night, and by the time we realized that we were under attack, it was already too late. Being carved out of this is simply telling you, I'm sorry, I know you did your best, but your best is not good enough. Affirmative defense is really no defense for us at all. Yes, we have that, but that requires defense after the suit is already filed. By that time, damage is already done to our reputation, individual reputation, and the staff morale. This is simply not feasible. As was stated previously, would you rather have your loved one cared for and getting the one-on-one care that they need, or would you accept the excuse of, I'm sorry, we didn't have the staff to take care of your mom in 5 minutes, 10 minutes, because my staff had to go be interviewed for this case right now. A lawsuit could very much be the final straw that closes a lot of the facilities. And the last point that I want to make for this is the what ifs of what's happening. Administrators and operators are leaving at a mass exodus because we don't know what's going to happen if we're open to these lawsuits. Could be the final straw, as I said. Crippling us, and it could have financial impact on the state because if a nursing home is no longer able to operate, we can go into a receivership where the state has to come in and has to be responsible also financially for taking care of the needs. And trust me, it's not a very inexpensive thing to do. So I will leave you with that. I appreciate the time here. We can't be painted as villains for doing the care the best that we can in unknown fights when no one else, especially stepping up to the plate, and we had no guidance. So I appreciate your time, and I'm happy to stand for questions at the appropriate time.
Thank you. Next, we have Michelle Ponce.
Good afternoon. Can you hear me?
We can, yes.
Thank you, Chair Patton and members of the committee. My name is Michelle Ponce. I am the Associate Director of the Association of Community Mental Health Centers of Kansas. We represent all 26 licensed community mental health centers across the state that provide behavioral health services in all 105 counties, 24 hours a day, 7 days a week, and they do so regardless of an individual's ability to pay. This makes the community mental health system the safety net for Kansans with behavioral health needs. We appreciate the opportunity to testify in support of House Bill 2126 today, and we're very supportive of the intent of the bill to provide immunity for healthcare providers for claims related to COVID-19 public health emergency. Over the past year, the COVID-19 pandemic has really driven home the fact that community mental health centers are essential service providers. During times of crisis, the need for services due to increased rates of anxiety, depression, and social isolation grows. In fact, our members have seen an increase in demand for crisis services throughout the past year. Throughout the pandemic, our mental health centers have very actively engaged in planning and developing policies designed to keep both their patients and their staff safe, and they've worked tirelessly to ensure continued access to care through innovative means. Whenever possible, they've provided services via telehealth. They've also done things such as making safety modifications to buildings and vehicles. They've limited the size of groups in terms of therapy groups to ensure social distancing. However, there are some services, mental health services, particularly crisis, that must be provided face-to-face. And as written, House Bill 2126 does not extend this immunity protection to community mental health centers. As essential healthcare providers, we strongly believe they should receive the same protections. And in closing, I would just thank you for the opportunity to appear before the committee today. And at the appropriate time, we request consideration of an amendment that would allow for inclusion of CMHCs in the protections provided under this bill.
Thank you. James Crable.
Can you hear me okay? Can you hear me all right now?
We can, yes.
Okay, great. Hey, thank you for giving me the opportunity to be able to testify today. My name is James Crable. I'm the CEO of Bluestem Communities. And Bluestem Communities is a nonprofit organization that has 4 different campuses. We're in Heston and North Newton and Newton, McPherson and Hutchison. We serve over 830 residents and we have 577 staff. We're an organization that since the beginning of CMS has received 4 and 5 stars every year at all of our organizations. And most recently, we received again a U.S. News and World Report of being in the top 15%. And we've received that for 10 times in a row now. When last legislative session, when this occurred and all healthcare organizations were included in being able to get liability, and you carved out the adult care homes, it was a real slap in the face. And so I went to Senator Owens and said to Steve, this is just not right. We were talking about organizations that care deeply about the people that they serve. We're talking about healthcare workers that come in the most in dangerous situations and trying to protect the residents that we love dearly. And so I want to say a great big thank you to Representative Owens. He was the sponsor of 2024 and now is very supportive of 2026. And the strange thing about all of this is that Kansas is the only state that was not included in the liability for adult care homes out of all of the entire nation. And I don't understand that, because Kansas actually has some of the best nursing homes in the entire country. And so that makes no sense to us. The other thing that is puzzling is as we went in for the fight of our life when it came to COVID-19, where you're talking about needing to have enough PPE and where you're talking about protecting our staff and our residents, it felt a little bit like Kansas was leaving out the heroes high and dry during the situation, which was not good at all. In Forbes magazine, the last 3 years, the most respected occupation is nursing. And it's viewed as the most honest and respected occupation. And for you to carve out those nurses from having liability protection makes no sense whatsoever. And so it's just not right and fair. I've talked to my colleagues multiple times, and the concern has been from the perspective of this is one of the greatest crises that we're dealing with. And it's really important when you're talking about needing the right amount of PPE and the kind of cost that we're dealing with. Last year, Bluestem Communities spent $1.7 million additional dollars to try to protect the residents and the staff that we have. And so and you think about that when you think about single sites and organizations all over Kansas, the amount of money that they're spending on that. The other thing that was a great concern is when you look at long-term care facilities and COVID liability immunity when it comes to general liability, our rates now with this that has occurred has now gone up by 10.3%.
James,
where in the last 3 years,
you've reached your 3 minutes. So if you want like a 10-second wrap up, you've got it.
All righty. So I just wanted to say, please, it's important to support the heroes of healthcare workers that have worked so hard to protect the residents. And I'm also very concerned because the residents are actually getting charged more dollars because of this lack of protection. So please, your support of 2126 is so important. Thank you.
Thank you. Linda Mowbray.
Thank you, Mr. Chair. I appreciate being here today. Are you able to hear me all right?
Yes.
Very good. I'm Linda Mowbray. I'm the president and CEO of Kansas Healthcare Association and Kansas Center for Assisted Living. We represent over 265 communities across the state, skilled nursing to home plus, everything in between. I appreciate having the opportunity to come today because I want to acknowledge something that many of you around the table on this committee and in the legislative body at the time need to hear. The nursing home, assisted living, and home plus worlds were shocked, devastated, hurt, and really didn't know what to do with being carved out of House Bill 2016. The thing is, we get it. You were between a rock and a hard place. In my testimony, I talk about Homer's Odyssey and being in that rock and a hard place. We get it. You had to pass House Bill 2016. No question about it. This is an opportunity now to go back and relook at that decision that was made to carve out the long-term care profession. This is an opportunity to set things right. In the simplest form, this bill 2126 simply puts us on the same footing as other healthcare professionals, and we feel like we need to be there because we are healthcare professionals. At a time when the general public was having trouble getting toilet paper, we were having trouble getting PPE. To hold us responsible for COVID coming into the building when we were doing the very best that we could just does not make sense. It's not how Kansas does business. We've had trouble with staffing. We had miscommunication and no communication between agencies, KDADS, KDH&E, when it came to where do we go for help? Where do we go for PPE? Where do we go for staffing? When each county, whether it was the health department, the health officer, or even the county commission, had a different take on what the home should do, that created chaos. Many of my members belong to organizations where they have homes in several different counties across the state. So when there was no consolidated message coming down, it was very difficult for our homes to make good decisions. They were following what the local said, even if it contradicted what another local said. The lack of understanding as well between the licensure types. You know, the information that was coming out would talk about nursing homes or something that CMS had done. Well, our assisted living and Home Plus are not regulated by CMS. And so the misinterpretation of information was very difficult for our members. I know that over the summer you met with many of your constituents, and many of them, thank you.
3 minutes.
Thank you. Your constituents know that you want to do the right thing, and they want you to provide us immunity to liability. With that, I will end my testimony and say, please carve us in, not out. Please pass 2126. Thank you.
Committee, you have written testimony from Matt Fletcher and Chris Erickson. Is there anyone else here or online as a proponent? Okay, good. Well, we stuck to my 425, except we didn't have time for questions. So we're going to have to go a little after 5. Let's do 10 minutes of questions, then we'll do opponents, 10 minutes of questions of opponents, and then we'll see where we're at. So Representative Samsel.
Thank you, Mr. Chair. One question for Michelle Ponce, please, directed towards the mental health centers. In a little bit, not to minimize this very important issue, but in slightly joking fashion, why were you guys left out? Did you make everybody mad? And then on a more serious way of phrasing that, is there a reason the opponents will say that you guys should not be included? Or help me understand that, please.
I wish I could answer those questions. I'm not sure why we were not included from originally, and I don't know why the opponents might want us to be kept out. We provide services to some of the most vulnerable individuals in our communities. Some of our mental health centers provide not only community-based service, but also residential care. And as you've heard from some of the other proponents today, we're also a system that is strained already to meet capacity and working and underfunded. So I'm just not sure I can answer those questions for you. I think we should have been included.
Thank you, Ms. Ponce. If one of the opponents could answer that in their allotted testimony time, that will save me a question, Mr. Chair. Thank you.
Thank you. Representative Humphreys.
Thank you, Mr. Chairman. I know that was 30 seconds, sorry.
even though the legal aspects are super interesting and very important, I would like to know possibly from Mark or Audrey, Rachel, somebody, what practical implications would this have? Would you, if we pass this, would you immediately open up a little bit and let people come in and out? What practical implications are we going to see? That's what I'm curious. Thank you.
For those online, it looks like Rachel's coming to the podium.
Yes, thank you very much, Mr. Chair. Rachel Monger with Leading Age Kansas. And so it's a two-pronged thing here. A lot of our visitation stuff that's going on and the isolation for residents, we are desperate to open up, but we do have to follow a lot of federal rules around that. Our hope is if something like this would pass, it would help us get there faster. I think there may be some missed opportunities that we are missing even with our visitation guidance to move forward faster, but we're seeing a lot of reluctance there because there is so much fear about what happens if you step a toe outside those lines because it's very, very drastic what could happen to you.
Representative Carmichael.
Thank you, Mr. Chairman. If I might inquire of my old friend, Mr. Maloney, please. As he's making his way up there, I certainly want to extend greetings to you, Mark. I didn't even recognize you when you first stood up to the lectern. It's been so many years since we've defended healthcare providers together. I guess my memory is poor, but I need to try to ask questions of 10 witnesses in only 2 questions. So it's a little difficult to do. Bear with me. Simple negligence in Kansas as it relates to healthcare providers and arguably nursing homes, assisted care, etc. I think you would agree that we typically look initially at the pattern instructions for Kansas, the 4th edition, and I know in the old days I used to have these memorized, but I'm looking at 123.01 and 123.02. And 01 is healthcare provider, 02 is hospital standard of care. But just to paraphrase a little bit from 02, the jury instructions that are given at trials, typically a judge is going to instruct on medical or scientific matters. A hospital's, or we could arguably say a nursing home or long-term care facility, standard of reasonable care is the same care, skill, and diligence used by hospitals in the same or similar communities and circumstances. I think you and I can agree that a healthcare provider or a nursing home is not the guarantor that a patient will not contract COVID, but rather they are only liable in negligence if they violate the standard of care, which is in fact dependent upon the circumstances. So isn't the standard of care different in the midst of a pandemic when you can't obtain PPE, when you don't know how the disease is transmitted, when you can't get staff, when families are locked out because CMS, the Center for Medicare and Medicaid Services, says they can't come in? Doesn't that change the standard of care in the midst of a pandemic as compared with what it would be were we 2 years ago, or presumably after it goes away like a miracle as President Trump promised us?
Representative Carmichael, first, I appreciate you commenting on my youthful appearance, and maybe that's what confused you from our experiences in the years gone by.
And I appreciate you not saying anything about my gray hair. I've been married 40 years today, and I didn't have any of this gray hair when I got married.
John, let me get right to it. I think we can agree on the definition of standard of care, and Representative Ralph on the committee spent a tremendous amount of time defending healthcare providers as well. We all know what the standard of care is 2 years ago. The point here is this is an unprecedented pandemic. This is unique. Nobody knows what the standard of care would be in this set of circumstances. And for my long-term care facility clients to be carved out and treated differently than my orthopedic clinics or my hospital clients, it's hard for me to explain to those clients. And as a result, the new bill 2126 cures that and goes a long ways towards leveling the playing field. And I think that should be the focus.
And so question 1.5 is that standard of care, even in these unique circumstances, is absent the common knowledge exception, is established by expert witness testimony from folks who are qualified by education, training, and experience in the management and operation of nursing homes. True?
That's true.
I've probably used my 2 questions. I'd like to ask an additional one, but maybe it's best if I wait, Mr. Chairman. I'll leave that to your discretion.
Let's go to Representative Owens and see how long his question takes.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. And Mr. Maloney, my question is actually for you. You talked a little bit about affirmative defense versus immunity, and I appreciate that explanation. You said you've defended our adult care facilities for quite a while. Can you step me through what happens if one of our adult care facilities files for bankruptcy? What's the steps? What's the state's involvement, and how does that generally play out?
You know, I have no firsthand experience in that set of circumstances, Representative Owens. I can anecdotally explain to you what I understand the process to be. I think there is a receivership that is established so that there is, I see some other folks nodding their heads, so that the facility can continue to operate, because they do have residents that are receiving day-to-day care, hour-to-hour care, frankly. And that, I believe it's a state-based receivership that takes over the facility to ensure a continuity of care.
Okay. Thank you for that explanation. I appreciate knowing that our state steps in to lead our adult care facilities, because after all, we do such a fantastic job with our children in foster care. So let's keep that in mind as we make decisions about our nursing homes.
Representative Jennings.
Thanks, Mr. Chairman. Maybe for Audrey Dunkel, since she has experience with both provider types being hospitals and adult care. Audrey, you are familiar with the bill passed by the legislature that granted hospitals special treatment and kind of left these adult care facilities at a little different place. Can you tell me whether or not what is contained within the law right now as it pertains to the special circumstance of COVID and COVID liability for hospitals, how does that differ between what's going on with hospitals now and what the proposal is that the committee has before it today? Are there differences in how those two different types of organizations would be treated if this bill passed as it is right now?
Thank you, Mr. Chairman. Excuse me, Mr. Chairman. My understanding is that this would then, excuse me, that 2126 would then treat them equitably, give them the same standard of liability protection. And I would defer to the revisers if there is any nuance in that that is different, but that is my understanding.
Mr. Chairman, there is one difference with the healthcare provider section. Well, I mean, there are actually a couple differences between the sections. If you look in the healthcare provider provision, which is 605503, subsection C2 limits this liability protection by saying that the provisions of the section do not apply to healthcare services not related to COVID-19 that have not been altered, delayed, or withheld as a direct response to the COVID-19 public health emergency. That language doesn't appear in this bill. And then additionally, the lead-in language on this adult care home liability creates immunity for any COVID-19 claim, whereas in the healthcare provision, it provides immunity from civil liability for damages, administrative fines, or penalties for acts, omissions, healthcare decisions, or the rendering of or the failure to render healthcare services.
Good. Okay. because I'm such a nice guy and I have no plans tonight, back to Representative Carmichael for one more question before we move on to opponents.
Mr. Chairman, you are indeed a nice guy, and I do have plans tonight, so I'll try to keep it short. Is Ms. Phillips still on the line with us? Hello?
She appears to be. I don't know that yeah, there we go. She's popping up. I think she
Okay.
can hear you.
All right, good. Ms. Phillips, can you hear me okay?
Yes.
Okay, good. I listened during your testimony to your explanation that your facility is one that has maintained high standards of infection control and nursing care, and that for several years it sounds as if that you've had very favorable surveys from KDHE. My wife, having been an adult care administrator, I understand how difficult that is and how justifiably proud you are of that record. But I think you would also recognize that unfortunately there are some facilities that you compete with for patients and dollars, in a sense, that don't maintain those same high standards. Would you want to see us pass a law that says that substandard nursing facilities are immune from liability, not only for civil damages, but also from administrative fines or penalties that might be levied by KDHE and its surveyors, particularly in a circumstance where nursing homes are in essence locked down and families can't be there to see the type and quality of care? Is that something that you would recommend that we do, that we just give those facilities immunity so they don't even have to respond to KDHE anymore?
Well, I think that, no, I don't think that. I think that if we're negligent, then we should be held accountable for that, as I said earlier. But I don't think that just, even if you're a bad facility or a good facility, it's still getting in. So if they're doing what they can to keep it out and they're doing the best that they can, I don't think they should be held responsible for that.
You and I absolutely agree. I'd be happy to have my mother at your facility. Thank you, ma'am.
Okay, is there anyone here today as a neutral conferee? Do not see any. We will move on to opponents. First up, entering the room, Joe Molina. Look at that, you walked in, perfect time.
Chairman Patton, members of the committee, my name is Joseph Molina. I represent the Kansas Bar Association. I think at the outset, it needs to be said, adult home care workers, retirement home workers, nurses, you guys are heroes. That's an unequivocal fact, something you'll never talk me out of. What they've done over the last year is tremendous, monumental, and cannot be duplicated, ever. It is the most important thing that some of these people will ever do. And I appreciate that. The KBA appreciates that. What they do is critical. The manner in which they do it is also critical, which is why when something does go wrong, we need to actually have a review of that. And in our system in the United States, that review comes most often when the lawsuit is filed. And that's why I'm here asking that you guys preserve one of our fundamental principles, which is access to justice. You guys have a very difficult proposition in front of you. You have to decide the rights of an industry versus the rights of an individual. And I've heard reasonable approaches. I've heard stories about people not being able to get the type of leadership in instances, the type of protective gear that makes it harder for them to do their jobs. Which is why the affirmative defense makes a lot of sense here. It is a reasonable approach. We are here to say that that is probably the way we should stay. When we passed this bill, current law, I should say, in House Bill 2016, between then and now, nothing has changed. We still have to deal with this thing, right? It is still here. They can still avail themselves to the affirmative defense. And yes, it will be more expensive. Yes, it will be more time consuming, and it will be frustrating. But that is a system that we have set up. And that is what you guys will have to decide. How far do we tip the scales away from an individual rights to get into court versus an industry. And that is a very difficult thing for you guys to do. I do not envy that position at all, which is why I think we should leave it as it is. Allow people who believe that they have been wronged and at least an opportunity to get into court without having to overcome, which is a very high hurdle of wanton disregard and the immunity. And that's my first point. I know I'm running quick on time. I just have a quick issue or question about the language. It seems overly broad. When you talk about any claim, is that to say that the Kansas Attorney General's office is prohibited or they can't get past the immunity because it touches every claim? So they can't review this. That is a awfully high hurdle. If you're saying that the Kansas Attorney General's office, as written, does not have standing to actually have something like this be reviewed. I apologize. I know I'm pretty close to running out of time. Joe Molina with the Kansas Bar Association. Happy to stand for questions when appropriate.
Thank you. Next, we have Representative Coleman.
Chairman Patton and members of the committee, Representative Aaron Coleman, I represent my constituents in Wyandotte County, Kansas City, Kansas. There's three reasons why I rise in opposition to HB 2126. Number one, adult care homes should exercise reasonable care. If they do, they have no liability for negligence. Removing that incentive to provide safe care to these residents endangers those residents. The Declaration of Independence states all men are created equal. Nursing home CEOs shouldn't be granted a higher status than any other citizen. Everyone should be equal under the law. Number two, this immunity is unnecessary because for a jury to enter a judgment against the local nursing home, they would have to find that the conduct was grossly negligent. And the third point that I oppose this legislation for is we can see how legislation like this has played out in states like New York. One headline in the Guardian read, Governor Andrew Cuomo gave immunity to nursing home executives after big donations. Now people are dying. A New York Times story from last week with the headline, New York State severely undercounted virus deaths in nursing home, report says, raises the question of whether data on more than 300,000 nursing home deaths was withheld by the governor in order to avoid blame. If Kansas gives legal immunity to nursing home CEOs, it is, in effect, taking one of Democratic New York Governor Andrew Cuomo's most botched public policy proposals and introducing it here. I urge the members of the committee to vote no on HB 2126 to stop this morally bankrupt legislation that places protecting private profits over the health of our most vulnerable and defenseless citizens. Thank you.
Thank you. Next, we have Margaret Farley. I think Margaret's online. We can't quite hear you, Margaret. Still not. You're showing muted on my end.
Okay, how's that?
Very good.
Can you hear me now, Chairman Patton?
I can, yes.
And members of the House Committee on the Judiciary, thank you for the opportunity to appear here today on behalf of Kansas Advocates for Better Care. Protecting the rights of older adults and persons with disabilities is one of our organization's chief priorities. That is why we oppose House Bill 2126.
As we all know, COVID-19 has disproportionately targeted older adults and persons with disabilities. We in Kansas, recently a report by the KDHE, where at the time 3,808 people had died from COVID in our state. 85% of those people were over the age of 65. I'm sorry. People give up a lot when they move into a nursing facility. Many people, of course, do not want to do that. They give up their independence when they move into a nursing home. Pandemic then took away many more of their rights. The rights to see friends and family, to visit with them, the right to eat in the dining room, as was their usual pattern with the people they live with, the right to leave the facility. Some people even spent several months in their rooms. House Bill 2126 attempts to take away one of their last remaining rights, their right to a fair trial if they are abused or neglected. Infection control practices in nursing homes are key. In May 2020, the GAO released a report. The title of the report was the conclusion of the report. Infection control deficiencies were widespread and persistent in nursing homes prior to COVID-19 pandemic. Of all the nursing homes surveyed across the country by the GAO, 82% had one or more infection control deficiency, and many of the homes that had F1 also had persistent problems, up to half of them. In Kansas, the GAO found that 1/3 of the nursing homes were cited for non-compliance with inspection health safety standards, and they found that only 41 Kansas nursing homes had no infection deficiency cited, and 41% were cited for infection deficiencies during multiple consecutive years. The affirmative defense provision included in House Bill 2016 and passed during the 2020 session provides immunity for adult care homes which comply with the COVID guidance from state and federal governments. Compliant facilities should have nothing to worry about. The affirmative defense protects them. No one would disagree that poor performing homes should be held accountable to those injured. House Bill 2126 seeks to take away residents' rights to hold those poor performing facilities accountable for harmful or egregious practices. This affirmative defense strikes a fair balance between the people who live in nursing homes and those they trust to provide care for them. This provision preserves the right to fairness and accountability while helping to keep them safe, and therefore, for that reason, it should be maintained. Residents and family members expect that the care that they receive from facilities already complies with federal and state health, safety, and infection control guidelines. Our policies and our laws must focus on fairness for residents, accountability, and oversight to assure facilities are safely taking care of the people who have taken care of us. We ask you to oppose House Bill 2126. Thank you.
Next, we have Judy Balloam.
Hi. Good afternoon, Chairman Patton and members of the House Judiciary Committee. Can you hear me?
Yes.
Okay. I'm Judy Balloam. I am the AARP Kansas Volunteer State President. I'm a registered nurse and a former Navy Nurse Corps officer. And while working as a registered nurse in home care and hospice, I've also worked with long-term care facilities, and I believe myself to be an expert in geriatric care. On behalf of the 291,000 members in AARP Kansas, we oppose House Bill 2116. Very much for the same reasons that Margaret Farley talked about and KABC. The nursing home deaths across the country right now surpass 153,000 people. In the state of Kansas, in the last 7 months, more than 1,000 nursing home residents have died from COVID-19, which is nearly half of all the COVID deaths in the state of Kansas. Given this dismal number that our state has seen for the past 6 months, it's alarming that you would be considering granting those facilities immunity from liability when we should be focused on identifying best practices and improving outcomes for residents and care. Families all across Kansas are looking to you to protect the health and safety of their loved ones that are living in these facilities as their home. Therefore, we ask you to oppose House Bill 2126. Thank you.
Thank you. Next up is Mike Burgess.
All right. Thank you, Chairman Pat, members of the committee. My name is Mike Burgess, and I'm with the Disability Rights Center of Kansas. I'm the Director of Policy and Outreach, and it's my pleasure to appear before you today remotely. So I want to start off with saying I agree wholeheartedly with some of the previous conferees. They did a great job of articulating that. So I'll focus on what I think kind of the piece that we haven't covered enough today. And really that's who we're talking about. Who will really be impacted by this bill? We've heard a lot about some of the facilities and the types of businesses that want to be involved, and that's very important. The work they do is very important. But the folks who are truly going to be impacted by this bill are seniors and individuals with disabilities. And so this includes America's greatest generation that fought World War II on our behalf, all sorts of things. Those are the folks who are going to be impacted by this. The bill appears to grant what basically amounts to blanket immunity. I mean, it's pretty broad immunity, as the others have said. And, for that reason, and I'll go ahead and attempt to answer Representative Samsel's question ahead of time. We oppose the bill, and we would oppose, the amendments, the proposed amendments as well with that. And so, again, just keep in mind the folks who will be impacted by the changes in the bill, and ask you to oppose House Bill 2126. And Mr. Chair, I'd be happy to stand for questions at the appropriate time.
Thank you. Next on the list is Ashley Rickett.
Hello. Can you hear me?
We can.
Welcome for anybody. Okay. My name is Ashley Rickett. I am honored to present some testimony on behalf of the Kansas Trial Lawyers Association. We represent individuals in the state of Kansas who have suffered an injury due to the negligence of others in the state. And I would like to echo some of what KBA and others have said, which is it's a broad immunity that is being proposed, when in fact we do have a law in place that we went back and forth on. KTLA doesn't like immunity. KTLA doesn't like affirmative defenses. These are all special rules. But what happened was back in 2020, everyone got together and came up with these affirmative defenses. And they allow for the facilities to bring these defenses to prove that, hey, we're following the regulations. We're doing the best that we can. And if that's the case and it can be proven, there isn't going to be a lawsuit. That lawsuit gets thrown out. And so I know I've heard a lot of testimony amongst a lot of different individuals, and I know that the Kansas Stabilization Fund actually, they gave a report in December of 2020, when the report says that as of October 1st of 2020, these claims were only in 3 facilities across the entire state of Kansas. So what I would urge to you is that this affirmative defense is working. It's taking into consideration COVID and the complications that come with it. And if the facilities can prove, hey, we're following the public health directives, then that's something that's accounted for in this law that was well thought out, and everyone came together on that. And like I said, we oppose immunity regardless, because we feel like the court system is in place so that our seniors can have a voice, and so that they can be in court and find out whether or not that they have a claim. Of course, after that is heavily researched before they ever bring one to begin with. So I would urge everyone to oppose, House Bill 2126, because it doesn't protect our elders. And I think the state of Kansas wants to protect our seniors. We want to make sure they still have a voice when they need it the most. This just isn't a fair bill to have a special rule that is carved out for complete blanket immunity for nursing homes and these vulnerable residents. Thank you.
Barbara Hickert is next.
Good afternoon, Chairman Patton and members of the committee. I am Barbara Hickert, and I'm the State Long-Term Care Ombudsman. I'm grateful for this opportunity to offer our agency's testimony on House Bill 2126. And I'm here today on behalf of the residents in all Kansas adult care homes to ask you to not pass this bill. Many long-term care facilities work hard to adhere to high standards of care, and during this pandemic, they worked especially hard under some really incredibly difficult circumstances. But we know that from our work that the quality of care varies widely and that there are a number of facilities that do not meet those high standards or do not even seem to aspire to do so. These facilities are frequently cited by federal and state agencies for understaffing, lax infection control measures, and other serious infractions. Additionally, in November, the AP reported an estimate that for every 2 COVID-19 deaths in long-term care, there were 1 other resident who died prematurely from other causes. In my testimony, I've listed all the ways that oversight and monitoring of care have been limited for almost a year. Families and friends who normally act as informal advocates and who would interact with staff and discuss care issues and resolve them are no longer allowed inside to see firsthand what's happening with their loved ones. The state survey agency has been limited by the pandemic in conducting their annual inspections. While they have conducted numerous infection control surveys, these are relatively short and focus just on infection control and no other area of care. And additionally, our program has not been able to make on-site visits to talk to residents and to observe conditions inside the facilities. Long-term care residents in our country and in our state have suffered the most from this pandemic. Besides the number of resident infections and death, no other group of people have been stripped of their rights the way long-term care residents have. This bill is just one more right that would be taken away from them. To grant immunity to facilities is unethical and would endorse substandard care. Protection should and do exist for providers who act in good faith to meet standards of care. We must continue to hold facilities and providers responsible for the safety and well-being of their residents and to safeguard the rights of residents to assert their right as a citizen before a court of law. I'm happy to answer questions. Thank you.
Thank you. Is there anyone else here or online as an opponent? Okay, we'll move on to questions. Representative Samsel.
Thank you, Mr. Chair. I have one question for Mr. Molina, one question for Mr. Burgess, if that's okay. As he approaches the podium, I probably would have left this unsaid prior to the attack on our nation's capital, and it's not the first time I've said it. But man, the language matters to me because the sky is following rhetoric. And when I hear things are described as morally bankrupt or egregious conduct that's not being dealt with, or we're taking away people's rights, it just strikes me that we're unnecessarily causing fear into the people that we're all trying to help. So in my personal opinion, that's an observation. It seems like to me, and please tell me if I'm wrong, but it seems like the real debate today is whether we're going to have an affirmative defense in these situations, which I understand to be the status quo, versus a little bit more protection or a lot more protection, depending on your view of the world, but civil immunity. So my question then for Mr. Molina is, am I wrong in that we gave civil immunity, if you will, and that's not a perfect description, but businesses out there already have those protections. So if you're a patron or somebody going to use those, or you're one of those restaurants or business owners, you're already getting civil immunity, if you will, versus this affirmative defense. Am I accurate in that?
I believe that's the case.
Okay, and why is then the Kansas bar opposed to granting our adult healthcare facilities the same protection then that we've already given to business protections? And maybe we should have never given it to business to begin with, or restaurant owners, if you will. But is there some reason we should not, as a matter of fairness or equity, be treating them the same?
Well, first of all, when this first came up under House Bill 2016, we did oppose the entire immunity provision. So we're not switching positions if we're responding to this specific bill. And secondly, none of this is fair. Honestly, COVID isn't fair. right? COVID isn't fair to the nurses and the homes, the residents. They're not fair to my kids who haven't been able to see their friends for 9 months. None of this is fair. And it's very difficult when we have a situation like this to base everything off fairness. So I urge you to look to what is reasonable under the circumstances. Right? What is reasonable when we look at the situations that these institutions are facing? And I believe the reasonable thing to do is to keep in place the law you passed just 9 months ago and just extend it, I believe, right? Keep the affirmative defense. It allows them protection. It gives them protection, right? They have a way to deal with these types of lawsuits while also maintaining an individual's right to get into court and have their case heard. It is a balancing test. And that's what I'm asking this committee to look at, the balancing test. And we have not switched our position from previously, but we're just responding to this bill. I hope that answers the question.
Well, Mr. Molina, it kind of does, but my question more specifically, and I get that it's maybe not fair, but wouldn't it be better for the bar, lawyers, judges, citizens of Kansas to have one standard applied across the board rather than lawyers learning one standard that involves an affirmative defense versus other standards that are civil immunity versus any other of these more minute issues that pop up?
Well, that would be preferable, and we would preferably have no immunities, what we said last year when we actually took a position of not having any protections. But since we're dealing with this situation now, we feel that we should keep with this situation and move forward from there.
Thank you, Mr. Molina. Mr. Chair, I did have that was 2 questions. I do have one for Mr. Burgess, but I can yield the floor and wait if there's time.
Go ahead and ask your question. He's ready.
Thank you, Mr. Chair. Mr. Burgess, I appreciate you noting my commentary earlier. Is your opposition, Mr. Burgess, to just extending amendments to include additional folks regardless, or is there some specific opposition to the mental health care providers?
It's our perspective is we oppose the bill, and the amendments would just extend that to other entities. So all disability providers, including the mental health centers, we would oppose adding.
So nothing personal with Mrs. Ponce or the mental health care centers?
Absolutely not. We work with them all the time through the Mental Health Coalition and a number of other groups and have a lot of respect for the work they do. Our job is to represent individuals with disabilities and their rights, and that's so it shouldn't be any surprise where we're at or why we're where we're at on this bill and the proposed amendments.
Thank you, sir. Thank you, Mr. Chair.
Representative Carmichael.
Thank you, Mr. Chairman. I suppose I ought to disclose a bit of interest. I belong to the Kansas Bar Association for nigh on 40 years as well. And so I'm a member. I just certainly ought to disclose that. And with that, I do have questions for Mr. Molina, should he still be available.
He's ready.
Yes, sir.
All right. This is perhaps a little bit unusual question, one I've never tried asking before. So if I mess it up, bear with me. But we've heard testimony here from the Kansas Trial Lawyers Association. By the way, I belong to that organization as well. I pay a lot of dues. Kansas Trial Lawyers Association, we have the Kansas Bar Association, there's the Kansas Association Defense Council, and there's various healthcare provider associations and on. But can you explain to us the process that the Kansas Bar Association goes through before they send you up here to say extending immunity to nursing homes is not necessarily a good idea? How do you arrive at these positions? Are you here as an advocate for the plaintiff's bar versus the defendant's bar versus the insurance bar, et cetera? Can you give us a little background on why you're here?
Well, when we talk about large issues, one of these is part of our mission statement. It's access to justice. And this is something that would basically limit access to justice for a very specific set of people. And this is something that has gone back as one of our policy positions well before I was with the Kansas Bar Association. When we have specific bills like this, it is run through a section review. We have 32 individual sections. We have a litigation section, which is comprised of plaintiff and defense bar members. They give a recommendation based off our past policies. And we do kind of have a ranking order about how important, I should say, a specific thing is to justice, I should say. They give a recommendation that is then run through our legislative committee who meets annually to review all these bills. And then they make a recommendation, again, after reviewing the language with our policy position, that goes on to our Board of Governors, which has 32 members. We meet 6 times a year. We actually have another meeting next Friday where we'll be discussing most likely this bill and see where it's going and what our position will be or whether to continue that position. And so we have a pretty rigorous review standard when we're looking at bills. And so that's how you actually get me up here in front of you for very specific things. And this is a big ticket item to us because it touches on our mission, which is maintaining access to justice for individuals.
You're muted, John. Not that we don't like it that way, but I think you want us to hear you.
Mr. Molina, you got away. This access to justice, is it just limited to, is this a plaintiff defendant issue, or is this free and open courts for everybody? Plaintiffs, defendants, a level playing field for everybody that the Kansas Bar Association advocates for?
It is for everyone. It is wherever we see that it could be limited. We would like to make it known that the Kansas Bar Association would oppose the limitation of access to justice. And so it is not one side or the other. I'm not here advocating for the trial bar. They have their own very qualified individuals who do that for themselves. I'm not here to advocate for the defense bar. Again, you heard from a defense attorney today. They have very qualified, very smart people to do that for themselves. I'm here strictly to promote the idea that access to justice is near sacrosanct, and we should protect that when looking at specific bills.
Thank you, Mr. Molina. I appreciate your testimony and your time. Thank you, Mr. Chairman.
Representative Owens.
Thank you, Mr. Chairman. Mr. Molina, you're off the hook. Not for you. You're good. You're off the hook, buddy. This is actually pointed towards Ashley Rickett. And Ashley, thank you for your testimony. I did have a couple of questions. As you shared with us that the Kansas Trial Lawyers Association was involved in the working with policyholders and stakeholders in the 2020 special session to craft provisions of the COVID-19 emergency. Did you guys at that time advocate against immunity for the hospital association, for the businesses and things like that as well?
I am not sure. I'd have to get back to you on that part. I was focused on the nursing home part for today.
Okay. Well, you talked about how this is, carved out a niche. You referred to that specific terminology, and I'm trying to understand how during those deliberations we carved out a niche that opened up liability to our nursing homes. That's what I'm trying to understand, because it seems like we did a very good job of providing the necessary protections for nearly all other industries in this state, but we just carved out this piece that made it, one could argue, easier for lawsuits to occur for nursing homes than it is a hospital at this time. Is that a fair assumption?
I don't believe so. I think that this immunity is provided through the affirmative defenses that were agreed upon. And it's because the nursing homes, they're not the front line that receives patients as hospitals do. They are housing our seniors. And it's not healthcare. It's 24-hour protective oversight of residents. And we did carve out, and in opposition to what KTLA would like, because we believe that the laws that are in place to allow you to bring your case in court should be enough, because they provide a lot of barriers and to access, and if you don't have a claim, then you can prove that in front of the judge and jury. But we came to and we made some compromise here, and there's some very specific examples that are pretty broad to show that if they have followed the public health care directives, then they are in essence immune from suit.
Okay, if I may, Mr. Chairman, continue along. So I just wanted to clarify something that you said, Ashley. So it's the position of the Kansas Trial Lawyers Association that the nursing homes and adult care facilities do not provide health care?
No.
Wow.
I did not. No.
Very interesting.
No, I'm not. I'm sorry.
That's
like a double negative.
4 years my father sat in one, they provided an awful lot of health care.
No, that's not what I intended to say. I think it was a double negative. They do provide health care. I would say yes.
All right, thank you for acknowledging that. One last question, and then I'll yield the floor. Under the current proposal in this legislation, it clearly states that the provisions of this section shall not apply to civil liability when it is established that the act, omission, or decision constituted gross negligence or willful, wanton, or reckless conduct. Does that still not leave our nursing homes open to liability if they fail? If they're not doing what they're expected to do?
If, in fact, you can meet the standard of gross negligence, willful, wanton, or reckless conduct, I agree that those claims will be there.
Okay, well, I just wanted to clarify that they're still liable. There's still liability in this bill. And we are simply elevating them to the same status as our hospitals and our other healthcare providers. And since we've established that they are healthcare providers, I think it's pretty important that they get the protection. So thank you, Mr. Chairman.
Any further questions, committee? Any questions for either proponents or opponents? Okay, don't see any. Going to close the hearing on House Bill 2126. Committee, we have 3 bill hearings tomorrow, which means we probably will not have time to work bills, but that does, I'm going to give you a list anyway, just in case. We have, and I'll give you a little description of what they were, just in case you don't remember. House Bill 2001, which creates the crime of sexual extortion. House Bill 2075, that had to do with venue in an adoption case. House Bill 2096 is the one that Ed Klump brought regarding public access to information for addresses of certain classes of individuals. 2109, that's the one that has to do with the make up the big bids board that we passed out of here last year. And then House Bill 2120, which has to do with the spousal exception to the crime of sexual battery. So if we get to those, we will certainly try, but I don't intend to go past 5 tomorrow. So we'll do the 3 hearings and see where we end up. That's it for today. We'll see you all tomorrow. Have a good evening. Thank you.